Hello and welcome to the Dementia Capable webinar series provided by the Rosalind Carter Institute for Caregiving in partnership with the Georgia Division of Aging Services. Before getting started, we advise having a pen and paper ready to write down any information and links to the resources as they are provided. Otherwise, you will have to view the webinar again to retrieve it later. You may pause the webinar now if needed. Remember that the link to the SurveyMonkey post test will be pasted onto the last slide. The post test will remain open for an indefinite amount of time. Please take it at your earliest convenience, though we encourage immediately following the webinar. A certificate can be provided when entering your email address at the end of the post test. Today's webinar will be Legal Issues for People Living with Dementia and Their Caregivers, presented by Robert Goldberg. Bob graduated from the United States Military Academy at West Point, New York in 1982 with a Bachelor of Science degree in engineering. After serving as a helicopter pilot in the Army, Bob attended the University of Michigan Law School in Ann Arbor, where he received his Juris Doctor degree in 1990. He has been practicing law since then. Bob and his team have specialized in estate planning and elder law since 1999, where he attended a continuing legal education seminar called Your Aging Parents, What Every Attorney Needs to Know. Bob is a member of the National Academy of Elder Law Attorneys, Wealth Counsel, and is accredited by the Veterans Administration. Bob has been married to his wife Kimberly since 1995. Kimberly and Bob have two boys, Simon, who is a freshman at Colorado School of Mines in Golden, Colorado, and Seth, who is a senior at Stars Mills High School. Bob enjoys reading, running, orienteering, going to the movies, and watching his favorite sports teams on television in his spare time. Welcome, Bob.
Thank you very much, Elizabeth, and I want to thank the Rosalind Carter Institute for inviting me to talk about what I think is a very important topic. And I want to welcome all of the caregivers here and assure you you're doing a very important thing, and there'll be a very great place in heaven for you. You've already heard my biography, so I'm not going to dwell on that, but I do want to introduce my team. That's me in the top left corner. I'm Bob Goldberg. Elizabeth mentioned Kimberly Goldberg, my wife. She's also my office manager. As a life care planning law firm, we have a registered nurse on our staff. That's Rebecca Mashburn. She's our care coordinator. We find that people don't understand how they own things and the importance of titling. So we have a staff member, Stephanie Smith, dedicated to being our funding coordinator. Miranda Royals focuses on probate, and she also prepares and files our Medicaid applications. Brandy Hatchett is our client relations director. She's who you talk to when you call us first time. Ashley Buchanan works as our marketing assistant and makes all of our marketing materials look pretty. Morgan Chain is our litigation specialist, and she does a lot of support for me in the guardianship and conservatorship area. And we had an office cat, and that's Miss Kitty on the bottom there, and may she rest in peace. As a former Army officer, I found it's always good to have learning objectives, and my objectives for all of you caregivers with me today are to help you plan for incapacity for the person you're taking care of. I want you to know the 3 questions of elder law. I want you to learn about the methods of paying for long-term care. I'm going to give you an overview of Medicaid planning, and I'm warning you that it's going to be like drinking from a fire hydrant, so don't be overwhelmed. I'm going to talk about VA benefits, specifically the pension benefit with aid and attendance, and I'm going to talk about questions you should ask when choosing an attorney. Now, many of you have probably heard this a lot. This is Roz Chass, and I recommend it to every caregiver. That's her on the right wearing the yellow. And every time she would sit down with her parents, her father would say, "Can't we talk about something more pleasant? You know, no one wants to talk about this." And my first bit of advice to you is what they told me at West Point on the first day, which was keep your sense of humor and don't take it personally. You are in this for the long haul, and I keep a copy of this book on my desk, and I refer to it often, and I have my clients read it out loud to me. So when you're told, can't we talk about something more pleasant, say, no. You cannot talk about something more pleasant. You are caregivers for someone who has been diagnosed with dementia, and they're going to need help with their everyday activities. These are called our activities of daily living: bathing, eating, dressing, toileting, transferring. They will need help doing those things. You will be doing it for them. They're going to need help with their instrumental activities of daily living. Those are things like driving and shopping and cooking and cleaning and managing medications and even managing finances. So the first thing underlying legal issues for dealing with dementia is you have to plan for incapacity. It cannot be ignored. And there's a brand new Uniform Power of Attorney Act that has just been passed as of July 1st, 2017 in Georgia. And the most important thing about the new Power of Attorney Act is certain formalities must be required. It must be executed exactly as required by the state law. And what that means, there must be signatures done a certain way, and there has to be an attestation. And attestation is the act of witnessing something in writing at the request of the party making the same, and then signing it as a witness. So under the new law, in order to be valid, a power of attorney has to be signed by the person called the principal, that's the person making the power of attorney, in front of at least one witness, and all of these signatures have to be notarized and attested to. That means there needs to be a statement in the power of attorney that the principal asked the witness to sign, that it was at the direction of the principal, and that everyone was in the same room in the presence of each other and everything was signed. You can't sign this thing in parts. One thing that I have found with powers of attorney is that financial institutions, banks and brokerage houses will say that a lapse of time has made the power of attorney invalid. And under the new law, it expressly says lapse of time will not affect the power of attorney. So if you're acting as an agent for someone under a power of attorney, you can arm yourself with the new law when they tell you, no, this power of attorney is too old. You can go, no. The law says you cannot reject the power of attorney for that reason. Just this last week, I had a client who had a problem who went to a bank, so one of the banks that are all over the country, and the power of attorney I had done for her parents was rejected, and they said it wasn't on the statutory form. Well, the power of attorney doesn't have to be on a statutory form. It just has to be substantially similar to the statutory form. And if you ever get trouble having a financial institution accept the power of attorney, you can get an opinion letter from an attorney that the financial institution will review, and that will get the power of attorney accepted. Now, I always tell people they want to have a powerful power of attorney and not a pitiful power of attorney. And what I mean by that is you're going to see soon that Medicaid planning can be important, and off-the-rack power of attorneys don't have gifting powers or trust-making powers. They might not have lending powers or insurance powers or annuity powers. So we want to make sure that all of these powers we may need when incapacity happens are available so we can do Medicaid planning or VA planning. Another way to plan for your financial affairs if you become incapacitated is to create what's called a revocable living trust. And in a revocable living trust, you actually change title while you have capacity to a trustee who can be yourself, And then if you become incapacitated, say two physicians decide you become incapacitated, you can be removed as trustee and a disability trustee will take over. And the disability trustee will have what I call take care of instructions. And those are instructions to use your money and property to take care of you, or maybe you and your spouse. And by planning for incapacity, you avoid conservatorship. Conservatorship is where a petition is filed with the probate court where a person called the conservator is appointed to take control of the ward's finances. And as you can imagine, that's a little bit more complicated than coming into an attorney's office to sign a durable power of attorney for financial affairs, and it's a lot more expensive. Now, just because you have your financial affairs taken care of, that's not enough. You also need to sign healthcare advance directives, and this can be really unpleasant to think of, but there's three parts to the healthcare advance directive. There's the healthcare power of attorney, where the principal can appoint what's called the healthcare power of attorney or the healthcare agent to make their healthcare decisions when they're not able to make them themselves. The second important part is the HIPAA release. That stands for Health Insurance Portability and Accountability Act, and that permits doctors and other healthcare providers to talk to your agent and release medical information to them so they have what they need to know to make decisions for you. And the final part is the living will. Now, the living will has nothing to do with your property. What it does is it provides clear and convincing evidence of your end-of-life decision-making wishes. And I like to think of this as the answer to one very simple question. Am I going to be able to experience a meaningful life? And if you're going to be able to experience a meaningful life, well, you want treatment. But on the other hand, if you're not going to be able to experience a meaningful life, you're directing your doctors and your healthcare agent and your family not to prolong the dying process. And really the way I see it, you're choosing at the end of life to have what's called palliative care, comfort care, rather than acute care. And I recommend to caregivers and the people they're taking care of a book called Being Mortal, and that talks about end-of-life decision-making. It's called Being Mortal. And by signing healthcare advance directives, you avoid going into probate court and having a guardian appointed over your person. So now that we've taken care of planning for incapacity, we have to look at the three questions of elder law. And they're, where am I going to live, who's going to take care of me, and how am I going to pay for it? Well, you're caregivers, and you're probably caring for someone in the home, and you're doing this on your own. The next thing that you can see happen is that outside caregivers might be brought into the house. Now you get into the expense of it. And from what I've seen currently, it costs around $18 to $22 an hour to pay for a home health aide. So, suppose you're paying $20 an hour. Well, 4 times 20 is $80 a day for home care. That comes out to $2,400 a month for just 4 hours a day. If it becomes too much of you to take care of your loved one at home, you might become more of a care manager, and your loved one will move into an assisted living. And that can cost anywhere from $2,500 up to $6,500 a month. And finally, if a person needs help with their activities of daily living, bathing, eating, dressing, toileting, and transferring, they might need skilled nursing care. That's the nursing home. And that can cost anywhere from $5,500 to $7,500. So you can see it gets pretty expensive pretty fast, which leads to the question, oh my gosh, this is so expensive, how am I going to pay for it? Well, some people have enough money to self-insure. They can just write a check at the end of the month and pay for the care. Some people have gotten long-term care insurance before they got sick. And there are two types. There are traditional policies and hybrid policies. Under a traditional policy, there's a daily benefit. That can be, $100 a day, $150 a day, which would give you $3,000 to $4,500 a month in daily benefit to use towards care. The elimination period I like to think of as the copay. That's how many days have to be paid out of pocket before the insurance company starts paying. And typically, I see people pick 90 days as the elimination period. The term is how long you have insurance for. That can be a year, 3 years, 5 years. And it's very important to have inflation protection because the cost of care is going up and you want the benefit pool to increase over time. That's a traditional policy. Now, the insurance industry saw that people didn't like paying premium for something they might never make a claim for, so they came up with the idea of a hybrid policy. And a hybrid policy is where you buy a insurance policy, a life insurance policy, and it has what's called a rider. And the rider typically says that if the insured needs long-term care, they need help with their activities of daily living, they can draw on the cash value of the life insurance policy to pay for their care. But what if you cannot self-insure? Or what if it's too late and the insurance company won't provide you with long-term care insurance? You're going to have to look at public benefits to pay for care. And there's basically 3 types of public benefits that are available to help pay for care. There's Medicare, Medicaid, and veterans benefits, and I will talk about each of those in turn. Starting with Medicare. I want you to all to think of Medicare as insurance. Look at the word care. It's health care for people over the age of 65. That's old people. I resent that since I am 57 right now. It's for people who have been disabled or for people with end-stage renal failure. And there's 4 parts to Medicare. And when you're thinking about insurance, remember that insurance is for anyone who has the insurance. It doesn't depend on how wealthy you are or how poor you are. And if you qualify for Medicare, you get 4 parts. Part A is hospital insurance. Part B covers physicians, your visits to the doctors. Part D covers your prescription drugs. That's Part A, B, and D. That's traditional Medicare. Part C is what's called Medicare Advantage plans. And you're seeing a lot of commercials on TV right now because it's the open enrollment period. That goes from around December through January when you can change your enrollment, and Medicare Advantage plans are private plans that replace traditional Medicare. Now I'm going to talk in depth about the Part A hospital insurance. And what Part A pays for is a skilled nursing benefit. The important word being skilled. It pays for skilled nursing and skilled rehabilitation services. And typically someone has a fall or someone has a urinary tract infection and they go into the hospital and they're admitted. And if you're a caregiver, it's very important to make sure your loved one has actually been admitted to the hospital, that they're not just on observation status. Because if they spend 3 midnights as an admitted patient under Medicare and their hospital stay is being paid for, then they can be discharged to a skilled nursing facility, that's the nursing home, for skilled nursing benefits. So typically people will get physical therapy, occupational therapy, speech therapy. That's the skilled rehabilitation benefit. Days 1 through 20 of the skilled rehabilitation benefit are paid at 100%. Days 21 through 100, there's $168 a day copayment. Now, the very important thing to know about Medicare Part A hospital insurance is it will not cover custodial care, the care required by a person who has dementia. It only covers skilled care. So we have to look at Medicaid to cover custodial care. And I want you to focus on the word aid and think about who Congress is going to help with medical care. Who are they going to aid? And they're going to help the needy. They're not going to help everyone who's over the age of 65. So Medicaid is needs-based. And when we're filing a Medicaid application, certain things have to be proved. Citizenship or resident alienship status has to be proved. Proof has to be provided that the person applying for Medicaid in Georgia is a Georgia resident. We usually do that through a driver's license. A doctor will fill out a form required by the state determining the level of care, and the doctor must certify that a person needs help with 2 out of 5 of the activities of daily living: bathing, eating, dressing, toileting, and transferring. Then there's a length of stay requirement. To qualify for nursing home Medicaid, you got to be in the nursing home at least 1 day. Then there's an income test and a countable resource test. And I'm going to talk a lot about nursing home Medicaid qualification, but there's an important benefit that's available in the home. This is a home-based community service. It's called CCSP, Community Care Service Provider Benefits, CCSP. And you would apply for CCSP benefits through your local AAA, Area Agency on Aging. So you can Google Area Agency on Aging where you live and ask for a referral for CCSP. And if you qualify for nursing home Medicaid, you could qualify for home and community-based services that can give you some important help in the home as well. Now let's get into the 2 questions that answer, are you needy enough to qualify for aid? And the first is, what is your income? And I see a lot of fear when people come into my office. There's much misinformation and outright disinformation when it comes to Medicaid. And the rules are complicated, but the rules are the rules. And the first important rule is the name on the check roll. And I see this in a lot of couple cases where, the healthy spouse is worried, my husband has dementia and he's going to have to go into the nursing home, and all of my income is going to have to go to the nursing home. How am I going to live if all my income is going to the nursing home? And I have to reassure them, no. The state must follow the name on the check rule. And when determining income eligibility for Medicaid, the only thing that's going to be reviewed is the income of the nursing home spouse, the spouse with dementia, the sick spouse. And currently there's an income cap of $2,205. I don't know when you're listening to this, so this might change, but if a person has $2,204 in income and they're the nursing home spouse, $2,204 is less than $2,205, they would qualify for Medicaid. If a person has $2,206, $2,206 is greater than $2,205, they would not qualify for Medicaid because they are over the income cap. But all is not lost. And what you must remember when dealing with Medicaid and a lot of legal issues that you're going to deal with is that for every rule, there is an exception to the rule. And federal law specifically provides that a person or their agent under a power of attorney can create what's called a qualified income trust. And a qualified income trust does what it says. It's a trust agreement that holds the income of the nursing home spouse. It's a separate account that has to be set up. And if it's created and administered properly, the sick spouse will qualify for, or the sick person will qualify for Medicaid. And don't be frightened when you see the word trust. A trust is merely an agreement, and it's an agreement between two parties, a person I will call the trust maker and the trustee. And the trustee holds legal title to property for the use and benefit of beneficiaries. And the property at issue in a qualified income trust is just the income, doesn't hold assets. But if a person with too much money creates a qualified income trust, or their agent under a power of attorney creates a qualified income trust account and cycles their money correctly through it every month, they will qualify for Medicaid. The other important income rule you need to know, especially for spousal caregivers, is the Community Spouse Maintenance Needs Standard. That's the MMNA, the Minimum Monthly Needs Allowance. That's $3,022.50 as I am creating this webinar. And what this allows for is for money from the nursing home spouse to be diverted to the community spouse so that the community spouse is not impoverished. What this means is, suppose a community spouse just gets $1,000 from Social Security, and the nursing home spouse gets $2,050 from Social Security. Over $2,000 of that nursing home spouse's income is going to be diverted each month to the community spouse, so they'll have at a minimum $3,022.50 to live safely in the community. And then what the nursing home spouse gets to keep $50 of their income, and what's left over is called patient liability cost share. Think of that as the copay, and that's paid to the nursing home if there's anything left over after diversion. Of course, if there's a single person, there is no diversion, there is no spouse, and the state will pay the difference. That's called the vendor payment to the nursing home. So the nursing home gets paid in full. So those are the income rules. Next, we have to look at countable resources. And I want you to think of the story of Cinderella and what happened in Cinderella. At midnight, Cinderella's coach turned back into a pumpkin. And countable resources or assets or net worth are evaluated on the first day of the month, at midnight of the first month. And it's like a camera shot. Click, a snapshot is taken, and what happens when we take a picture? Everything is frozen in time. And a single person is only allowed to have $2,000 in countable resources in order to be eligible for nursing home Medicaid or community care service provider Medicaid. A community spouse can have $120,900 in countable resources. So if you do the addition, a couple can have $122,900 in countable resources. So when a person comes into my office in a Medicaid case, I have a big whiteboard and I ask them to bring all of their statements in, their most current statements in, deeds to their house, titles to their car, proof of everything that they own. I want to examine title. And I actually make 2 columns on my whiteboard and I make 2 piles on my desk. And the first pile is called exempt resources or non-countable resources. And I want to see what will not count first. And the first thing that will not count is a home place worth approximately $500,000. That just doesn't count when you're applying for nursing home Medicaid or home-based Medicaid. Household goods, the things in the home, do not count when you're applying for Medicaid. The value of one automobile will not count when applying for Medicaid. People are amazed when I talk about the next one. A retirement fund often will not count when applying for Medicaid. That's something like an IRA or a 401k or a 403b plan. The community spouse's IRA will never count, and oftentimes the nursing home spouse's IRA will not count because it's a retirement fund. And I've seen some really bad cases where people have been told, oh, you have a $250,000 IRA. That's more than $122,900 in countable resources. You're not eligible for Medicaid. And they'll come into my office after private paying for a year, and I'll say, no, that's not counted. Your loved one is eligible for Medicaid. Term life insurance, I often see this as part of a group policy, is not countable. It has no cash value. Burial funds, you're allowed to have a burial fund up to $10,000. A spouse can have a burial fund up to $10,000. And I've seen this trip a lot of people up because they will already have term life insurance, and the rules are tricky. The rules say if you have a term life insurance policy, it has to be used for your burial fund first. So you can't have a $10,000 burial CD and a $10,000 term life insurance and expect both not to count. Your burial fund bucket could be chock full with term life insurance. So you have to be really careful when you're looking at life insurance when applying for Medicaid. There's a separate exclusion making burial space items exempt. This isn't just the plot. These are things like the casket, the vault, the opening and closing of the grave, the marker. And a person can purchase burial space items, usually by purchasing a life insurance policy directly at the funeral home for themselves, for their spouse, for their children, and for spouses of their children. So that's a planning opportunity if it is done correctly, burial space items. So if I can't put things in the exempt pile, in the non-countable pile, the law says I have to put it in the countable pile. And I usually start out with the most simple thing. That would be a checking account into which someone's Social Security is going, a savings account, CDs, mutual funds, stocks, bonds, whole life insurance. Whole life insurance is life insurance that has cash value. And life insurance can be what I will call a tricky asset, a tricky resource, because it will be counted when evaluating eligibility for Medicaid. And it's a non-liquid asset. It's hard to spend a life insurance policy. It has to be surrendered or transferred, and it can take time. Real estate that is not the home place will be considered countable. So when I'm looking at Medicaid, usually people are coming to me in crisis, and they're worried that they have too many countable resources, and they've been told the only way to qualify Medicaid is to spend down. You're not going to be qualified for Medicaid until your countable resources get below the countable resource limit, $2,000 for a single person, $122,900 for a couple, and the only way to get eligible is to spend. But we can do some planning, and depending upon how much time we have, if we just received a diagnosis of dementia, we might have 5 years time with which to plan. I call that pre-crisis planning. We're planning within the look-back period. And the look-back period is the period of time that the government is going to look back from the time you make your Medicaid application to see if you've given anything away. And if you've given anything away, there's going to be a transfer penalty calculated. And the penalty doesn't mean anyone's going to go to jail or anyone's going to go to trouble. It's a math problem. So if you look at my example, we divide the amount given away by $6,175 a month. That's the average cost of nursing home care in Georgia. So suppose you give away $30,875, as you can see from my example. When I divide that by $6,175 per month, I get 5 months. That's the number of months that care has to be paid for in the nursing home privately because you gave away money that could have been used to provide for care. But we can use the rules to our advantage, and there's nothing wrong with that. An aggressive transfer can be made. And if an aggressive transfer is made and you don't apply for Medicaid until after the 5-year look-back period has passed, then what you have transferred will be protected. And we like to make transfers to what I will call a Medicaid Asset Protection Trust, which I will get into in a moment, and another pre-crisis Medicaid planning strategy I will talk about when I get done talking about with the Medicaid Asset Protection Trust is a family caregiver agreement. So what is a trust? I've already talked about this in the context of a qualified income trust or a Miller trust. It's an agreement that has to have at least 2 parties. A lot of times I see trust agreements where they talk about a grantor or a settlor or a trustor. I like to use plain and simple language. I like to call the trust maker because they make the trust. And they make an agreement with the trustee who will hold legal title to the property. And the trustee has a fiduciary duty towards the beneficiary to manage and use the property for them. The beneficiaries get the use and benefit of the property. And the important thing about a trust agreement, and particularly the Medicaid Asset Protection Trust, is that after the trust is signed, a second step occurs. I want you to think of this trust as a bucket that you create, and you actually give away what you own to the trustee who has control over this bucket. So you see a home, and you can deed a home from yourself to the trustee so you don't own the home any longer. You can change ownership of a life insurance policy. Remember that whole life insurance policy can have a cash value, and you don't want the cash value to count against you when you're applying for Medicaid. You might have a brokerage account, stock, or other cash, and you can change title from yourself as the owner to the trustee as the owner. Now, a mistake I often see is that people will come into my office and they'll say, well, I created a trust. Someone told me I can make a trust, and if I put my property into a trust, a bank account or my house, it won't count when I'm applying for Medicaid. And I ask for them, what does revocable mean to you? And everyone will answer, well, that means I can change it. And I tell them, well, if you can change it, you haven't really given anything away. You can take things back. And then I ask them, well, what does the little prefix IR mean? What does the in irrevocable mean? Well, means not. So an irrevocable trust is not changeable. So the important point I want you to learn from this is that a revocable trust will avoid probate. That's the purpose of a revocable trust. You want to avoid probate, to not have to go to court to pass title to assets when you die. An irrevocable trust will avoid probate, but it's going to give you asset protection as well. Things you give to the trustee of the trust are not counted, and there is no penalty when you apply for Medicaid after the 5-year look-back period. So why not just give property away directly to a child? Well, estate planning attorneys, elder law attorneys are very, very nervous. We have a saying, it's plan for the worst, hope for the best, everything else is wishful thinking. And we want to keep you in some control, the sick person in some control when they make a gift. So they can retain certain rights. They can retain a right to occupy the property. So they won't be forced to leave the property in the event of a death or divorce of a child who is given the property. There are property tax benefits from retaining a right to occupy. We can have a person keep a homestead exemption or a senior citizen exemption. There are income tax benefits to retaining a right to occupy property. There's something called the Section 121 exclusion, where there's no capital gains tax that has to be paid by the person who owns the property if they live in it. And you can get what's called a step up in basis and death that can avoid capital gains tax. The person making the gift can retain a right to income, which includes, as I've already said, the right to occupy real estate, the right to interest, the right to dividends, and the right to rent. And the big benefit of giving property away is it protects what you give away from being counted if nursing home care is needed after the 5-year look-back period. This is not an automatic solution. 5 years have to pass, and probate will be avoided. What are the disadvantages to making a gift or leaving property in trust? If you gift to a child, remember, you don't own anything anymore. You give up all the rights to the property. You can lose control. What if the child dies? What if the child is sued? What if the child gets divorced? Your property that you owned, you no longer own. It can be lost. The disadvantage of leaving property in trust, you have given away the right to the principal. You no longer own it. You only have a right to income, and that is the right to interest, dividends, rent, and the right to occupy the property. So a lot of you are probably family caregiver agreements. Did you know that you can be paid? If you're paid for your services, then there's no transfer penalty. So someone with dementia can pay a family member. It can be a child, it can be a grandchild, it could be anyone to live with you and help with their activities of daily living. But the law requires this family caregiver to be in writing. If it's not in writing, the money paid to the caregiver will be considered a transfer. But if you have a written agreement between the care provider and the care recipient, it will not be considered a transfer. It has to be on a monthly basis. There cannot be a lump sum given to a care provider. And very important to remember that an employer-employee relationship is created between the care recipient and the care provider, and that care provider is going to have to pay income tax on their wages. They're going to be considered an employee. But it's a really, really good way to take excess countable resources and pay for needed care so that when you need Medicaid in the future, the applicant recipient will be below the countable resource limit. Well, what if we've waited too long? What if there's a crisis? All is not lost, because if we look at the law, we will see that there are crisis planning strategies that can help pay for care. And they involve what I will call exempt transfers, which are exceptions to the transfer rules, converting countable to non-countable resources, and converting countable resources into an income stream. Here's the exempt transfers that are found in the law. These are exceptions to the transfer penalty. Spouses can transfer assets between them. And I always use this exception in a couple cases because I don't want my nursing home spouse to own anything except a checking account into which their income is going. I want the community spouse to own the home and all of the other assets. And the nursing home spouse might own an IRA because that's a retirement fund. That's considered exempt. There's an exception for transfers to a caregiver child, not a caregiver grandchild, not a caregiver niece, not a caregiver spouse, a caregiver child. And a caregiver child is defined as a child who provides care to someone in the sick person's home for a period of time of 2 years before they go into a nursing home. And in that case, a home can be transferred to a caregiver child. But note that the caregiver child has to be living in the home of the sick person for the 2 years immediately preceding the sick person's entry into a nursing home. And that transfer of the home would be exempt. A transfer to a sibling, a brother or sister who owns an equity interest in the home, will not carry a transfer penalty with it. The next important exemption is a transfer of anything to a disabled child or to a trust for a disabled child. And notice that it's a disabled child, not a disabled person. And the child must be disabled according to Social Security guidelines. And proof of that is a Social Security award letter. The next exemption is a transfer to a sole benefit trust for the sole benefit of a disabled person under the age of 65. We've used this in cases where there's a grandchild who's disabled. Perhaps you have a disabled child with autism or some other disability, and they're receiving Social Security benefits. Well, a special trust can be created by the trust maker for the sole benefit of that disabled person under the age of 65, and these are ways to reduce countable resources below the countable resource limit or to protect property from estate recovery. That caregiver child exception can be used to protect the house. Even though the house, the home place, isn't counted when applying for Medicaid, you're going to see in a few slides, if you own the house and have received nursing home care, it can be subject to estate recovery. Right. What if we can't make any exempt transfers? I want to look at converting countable to non-countable. And this works really well in the case where there's a community spouse. The community spouse can sell their less expensive house or move from an apartment into a more expensive home. Remember, you can have a home worth up to $500,000 and it's a non-countable resource, and this is a good way to protect assets for the community spouse. Home repairs can be made to the home that the community spouse is living in. The community spouse could trade in his or her old automobile for a newer, more expensive automobile, and one automobile, remember, is considered an exempt resource. Assets can be allocated to a burial fund if one does not already exist, and burial space items can be purchased from the funeral home in order to convert non-countable to countable resources. So after I've done those things, the next thing I will do is look at the law and see, can I convert countable resources into income. And this is something that works really, really well where there's a community spouse, because excess countable resources can be converted into an income stream for them. But this also works in a crisis Medicaid case for a single person, where we can convert excess resources into an income stream. And federal law says we can do this in two ways. A Medicaid compliant annuity can be purchased. However, the problem I see with this is the law in Georgia requires the state of Georgia to be named as the primary beneficiary after death. So another way to convert countable income into countable resources into income without there being a transfer penalty is to make a loan through what's called a Medicaid compliant promissory note. And I want you to think about the difference between a gift and a loan. When a person makes a gift, there's no expectation of ever receiving the money back. But what's the difference with a loan? If a loan is made, you have the person receiving the loan sign a promissory note. And a promissory note is a promise to pay the money back. And federal law says if every I is dotted and every T is crossed, if the promissory note is Medicaid compliant, there won't be a transfer penalty assessed, and excess countable resources can be converted into income. And this can protect all of the assets for a community spouse and about half of the assets in a single person case, converting countable into income. I mentioned estate recovery. So there's one set of rules regarding Medicaid eligibility, involving income and assets. The estate recovery rule is quite simple. It says if the person receiving nursing home Medicaid dies in a nursing home owning property worth more than $25,000, a claim will be made by the state upon their death, and that's called estate recovery. So it's a really good idea in a couple case for the nursing home spouse to not own anything so that an estate recovery claim will be avoided. Let's talk a little bit about VA pension with aid and attendance for those veterans out there. I'm not going to talk about compensation. VA compensation is for veterans who have a service-connected disability. VA pension is for needy veterans or their surviving spouses. And you have to have 90 days of active duty service, 1 day of wartime service, which means you have to have been in the service while a war was going on. You don't necessarily have to have been boots on the ground in the war theater. There has to be an honorable discharge. There cannot be a dishonorable discharge. If a spouse is making this claim, they have to be a surviving spouse. They can't have been divorced, and they cannot have remarried. And then the VA is going to look at net worth, and the veteran and or their surviving spouse has to have a low net worth. One mistake I see people making is they believe that they have to have less than $80,000 in net worth. I like to see people with less than $80,000 in net worth because the VA looks at what's called actuarial life expectancy. They look at what your income, they look at your expenses, they look at your net worth, and they look at how old you are and how long you're going to live. And I like to see people with lower net worth. Now, the important thing to know about net worth is that the VA currently doesn't have any look-back period, so aggressive transfers can be used when planning for VA pension. Now, the next concept we need to understand is income for VA purposes. And income for VA purposes is gross income minus unreimbursed medical expenses. So let's take an example. Let's suppose someone's income is $1,000 a month. Let's suppose they're a single veteran and their income is $1,000 a month. And let's say they have no medical expenses. $1,000 a month minus zero medical expenses equals $1,000. Well, they'd be considered a low-income veteran and could get approximately $700 a month in pension, VA pension, with aid and attendance if they require the help and assistance of another person to live safely in the community. But let's suppose the same veteran now has $2,000 a month in medical expenses. So $1,000 minus $2,000 is a negative number. And medical expenses can be money paid to a caregiver. Medical expenses could be money paid to an assisted living. So this could be a really good benefit for the veteran who is at home receiving care from a family caregiver or even from an outside caregiver, or for a veteran who's in an assisted living, because if you have a veteran who only has $1,000 and they're paying $2,000 for care, they have minus $1,000 a month in income for VA purposes. They'll be eligible for approximately $1,700 a month in pension. And this requires evidence from the doctor. It requires evidence from the caregiver or the assisted living that needed care is being required. But you can see where it can be very helpful to answer that question: how am I going to pay for care? The next thing I want to look at is estate planning when you have a beneficiary who's in a nursing home, particularly for the well spouse. I see a lot of I love you wills because people did planning back when they had a child, or they did their planning when they retired. They haven't done planning since a diagnosis of dementia was received. And if there's an I love you will, what happens if the community spouse dies first or another family member dies and leaves something to someone in a nursing home? Think about it. If a well spouse is a caregiver, the sick spouse has now lost their primary caregiver. They're probably going to need assisted living care or nursing home care. They're probably not going to be able to manage their assets. And if they own too much property, bank accounts, real estate, they might not qualify for Medicaid or VA benefits. So an I love you will can have what I call the boomerang effect. The money boomerangs back to the person with dementia and will keep them from qualifying for Medicaid. So I asked this question: should the nursing home spouse own anything besides their checking account and their retirement fund because it's exempt? And my answer is no. And the community spouse should create what's called a testamentary supplemental needs trust. Again, it's a trust, which is an agreement between a trust maker and a trustee, but it's a testamentary trust. It's a trust created in a last will and testament at the death of a person. And the trust is created to provide only for the supplemental needs of a person who might need Medicaid or is already in a nursing home. So we title everything except one checking account and maybe the retirement fund in the name of the community spouse. And when the community spouse dies, the gift left to the nursing home spouse in trust that's created in the will not count when applying for Medicaid or VA. And the money can be used by the trustee to pay for what Medicaid doesn't pay for, an upgrade to a private room, say, or payment for a private nurse to come in and give some additional care. And then when the nursing home spouse passes away, whatever's left in this trust account can go to other beneficiaries like the children. or the grandchildren. So where do you go from here? And, this is my favorite slide out of all my slides. This is the point of time in The Wizard of Oz where Dorothy and Toto are walking the yellow brick road trying to find the Emerald City, and they come upon the Scarecrow, and they're lost. And they ask which way should they go. And the Scarecrow goes, well, maybe you should go this way, and maybe you should go that way. And this causes great consternation. And you as caregivers are sometimes cause great consternation because you don't know which way to go. So I want you to learn how to ask the appropriate questions when you're getting help from an elder law attorney. And you should ask, what law school did you go to? Did they go to a top-tier law school or a middle-of-the-road law school? Is the firm's primary focus on elder law, or do they dabble in different things? You can't fake experience, so how many years of experience does the attorney and their staff have in helping clients with elder law issues? Does the attorney assist clients with preparing and filing the Medicaid or VA application? Because oftentimes what we find in our office is people have never filed a Medicaid or VA application, and we have done hundreds, if not thousands, because we know that clients and caregivers haven't done this before. Is there a flat fee or an hourly rate for providing services? A lot of people don't want to pay hourly rates because they never know what their bill is going to be. And the most important question you need to ask yourself is, can you see yourself working closely with this attorney and his staff? Because you're going to have a relationship. This isn't an event just drafting documents. Questions are going to be coming up over time, and you want to have a close working relationship with whoever you choose. This is the opposite of planning, and it causes great consternation. This is literally running around like a chicken with your head cut off. It's bad enough that your loved one has been diagnosed with dementia and you're having all of these caregiver responsibilities, and you want to avoid being a chicken with your head cut off. You also want to avoid this. The first thing you notice is that these people have their heads stuck in the sand. And I want you to look at this picture and think about this. When you have your head stuck in the sand and you're in denial and you're procrastinating and you're avoiding things, can you see the tidal wave coming behind you? And the answer is no. And when you examine this picture more closely, I want you to consider this. Is the head bigger than your behind? Because when you stick your head in the sand, you are in fact creating a bigger target. More problems will go wrong. My goal for everyone is for you to make peace of mind your priority. And I want to go back to what I said in the beginning. Keep your sense of humor. Try not to take this personally. You're in a bad situation. But if you make plans, you can give yourself some peace of mind. So, I thank you for your attention. This is Bob Goldberg from Robert M. Goldberg & Associates, wishing you a Merry Christmas, Happy Holidays, and a Happy New Year. You have our contact information up here if you need to get in touch with us. We have an office in Peachtree City, Georgia. We have another office in Griffin, Georgia. Our telephone number is 770-229-5729, and you can find information about us on the web at www.goldbergestateplanning.com. So thank you very much, Elizabeth, and I'm going to turn it back to you now.
Well, thank you so much, Bob. It was such a pleasure. Just a reminder to the viewers to please go to our post-test link that is pasted on this last slide. We encourage you to take the post-test at your earliest convenience. A certificate can be provided by entering your email address at the end of the post-test. Please remember to view the other webinars in the Dementia Capable webinar series provided by the Rosalind Carter Institute for Caregiving in partnership with the Georgia Division of Aging Services. Thank you, and we hope you'll join us again.